Good afternoon, everyone. Welcome to the Louisiana Department of Education Division of Nutrition Supports training on civil rights and child nutrition programs. My name is Stephanie Loop. I'm an education program consultant with the division, and I will be your trainer today. The purpose of civil rights training is to inform, educate, and support all staff that interact with child nutrition programs. This training will cover USDA civil rights requirements, staff responsibilities, and resources and information available to assist staff in carrying out their civil rights responsibilities. First, we'll discuss public notification systems. This is the process by which the SFAs notify potential applicants of the availability of meals. Second, we'll discuss civil rights issues related to customer service practice. This could occur anywhere in the continuum of participation, from applicants turning in free and reduced price meal applications to overt identification of meal status in the lunch line. Third, we'll cover the requirements to collect race and ethnicity data and why that information is collected. Fourth, we'll briefly touch on issues of accommodating children with special dietary needs. This is not a complete special dietary needs presentation, but we'll cover the topic from the lens of ensuring equal access. Fifth, we'll discuss what an SFA should do if they receive a complaint alleging discrimination in the school nutrition programs from a student or a parent. We'll discuss what an SFA should do if there are areas of noncompliance and how to handle reporting of compliance issues. And finally, we'll discuss language assistance requirements. There's a number of civil rights laws pertinent to child nutrition programs. Title VI Civil Rights Act of 1964. This prohibits discrimination based on race, color, and national origin. Title IX of the Education Amendments of 1972 prohibits discrimination based on sex under any education program or activity that's receiving federal financial assistance. Even $1 of federal assistance brings the entire scope of federal child nutrition requirements into play. And Section 504 of the Rehabilitation Act of 1973 prohibits discrimination based on disability. Additional civil rights laws include Americans with Disabilities Act of 1990. This prohibits discrimination based on disability in all services, programs, and activities provided to the public by state and local governments, except public transportation services. And the Americans with Disabilities Act of 2008, or the ADAAA. This was followed by the Age Discrimination Act of 1975. This prohibits discrimination based on age in programs or activities receiving federal financial assistance. Civil Rights Restoration Act of 1987 prohibits discrimination based on race, color, and national origin. Here are some other resources and authorities on civil rights and child nutrition programs. What I want to draw your attention to is FNS Instruction 113-1, which is entitled Civil Rights Compliance and Enforcement, Nutrition Programs and Activities. This guidance covers the scope of civil rights laws in child nutrition programs. So what is discrimination? Discrimination is defined as different treatment, which makes a distinction of one person or group. This can be intentionally, it can be by neglect, or by actions or lack of actions based on the protected classes. Examples of discrimination include giving one group or type of participants larger or extra helpings of food, such as giving boys more than girls. This could be separating genders. This could be failing to provide children with a dietary disability an accommodating meal. This could be failing to provide program information to all potential program applicants. Protected classes in the child nutrition programs are race, age, color, sex, national origin, and disability. This means that an alleged discrimination complaint will pertain to one of those areas. And we're going to repeat those a couple of times throughout the rest of this presentation. Civil rights training is required annually for all staff, and that's why we offer this training every quarter. This includes full-time staff, part-time staff, temporary staff, central office, site staff, and volunteers. Documentation for civil rights training must be maintained for 3 years plus the current year. And the documentation must include sign-in sheets, agendas, and the dates and the times of training. All civil rights training should be tracked on a training tracking tool. And we have a couple of options here. You could use USDA's Professional Standards Training Tracker, or you can use the Louisiana Fit Kids version, which is on the louisianafitkids.com website. Civil rights training subject matter must include the following: the collection and use of data, effective public notification systems, complaint procedures, compliance review techniques, resolution of noncompliance, requirements for accommodation of persons with disabilities, requirements for language assistance, conflict resolution, and customer service. All FNS assistance programs must include a public notification system. The purpose of public notification is to inform all applicants, participants, and potentially eligible persons of the program availability, the program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. Through public outreach, SFAs are trying to ensure program access to as many potential participants as possible. Public notification must include information regarding eligibility, benefits and services, program availability such as the hours and locations, applicant rights and responsibilities, procedures for filing a complaint, non-discrimination policies, and any program changes. Schools must notify the public annually of their participation in the program. Notification to applicants and participants must include information regarding program availability, program rights and responsibilities, the procedure for filing a complaint, and the policy of non-discrimination. The public notification system must include the following elements. Number 1 is the public release. So schools must take specific actions to inform the public of their program rights and responsibilities and the steps necessary for participation in the program. Number 2, programs must display the And Justice for All poster. It must be displayed in the correct size, which is 11 inches by 17 inches, and it must be in a prominent location where it's visible to all participants in the program. The poster provides the USDA address and phone number that the public can use to file a complaint if they think that their civil rights have been violated. Applicants and participants must be advised of their right to file a discrimination complaint, of how to file the complaint, and of the complaint procedures. And then number 3, the non-discrimination statement. All informational materials, including websites used by schools to inform the public about FNS programs, must contain the non-discrimination statement. So public notification can include methods such as the internet and computer-based applications, the newspaper, radio or television, letters, leaflets, or brochures that are sent home to students, bulletins. And we also want to note that you need to make sure to convey the message of equal opportunity in photos and other graphics that are used to promote the program information to applicants or participants. The media release must be provided at or near the beginning of the school year to the local news media, the unemployment office, and to any major employers that are contemplating layoffs in the area. The media release must include the eligibility criteria for free and reduced meal prices. For CEP schools, the media release should inform the public that school meals will be free to all enrolled students, and that would be the same for this year with the SSO waiver. It's at the discretion of the media if they decide to publish the media release. Another method of public notification is informational letters that inform households of program availability. Informational letters must be distributed by schools at the beginning of the school year by mail, email, or they can be given out in person. Letters cannot be sent at the end of the school year for the following year. So in other words, they must be sent after July 1st, preferably before the start of the new year. We stated this on a previous slide, but all SFAs must prominently display the USDA non-discrimination poster and Justice for All. Again, it must be in the original size, and they should be displayed in each school and in a location that's easily visible to the students and the public in the food service area. If you are in need of this current poster, so in the past we've had the Statue of Liberty, and now we've moved on to this government building with the flag in front. If you are in need of posters, please contact the state agency, and we will be happy to either mail or deliver some to you depending on where you're located. The USDA non-discrimination statement must be included on all forms of communication and program materials. Program materials include all public information and education. The long version of the non-discrimination statement is required on all documents pertaining to student eligibility, such as prototypes of letters to the households, verification, and direct certification. The long version of the non-discrimination statement should also be used whenever possible or if space permits. The short version of the non-discrimination statement can be used if the document's too small and there's limited space, such as on menus and nutrition flyers. If using the short version of the non-discrimination statement, a 9-point font is required. And we actually encourage that you use the same font size. So if you're using larger than a 9-point font, to use the same font size as the rest of your text. This is the long version of the non-discrimination statement. The state agency does keep this long statement on the homepage of the C&P website. And one quick check to see if you've got the right non-discrimination statement, because there are statements such as for WIC or for SNAP, you can check on the protected classes. So here we have race, color, national origin, sex, disability, and age in that first paragraph. That's 6 protected classes, which are the 6 that are protected under our programs. This is the long version of the non-discrimination statement in Spanish, and there are additional languages available online at www.fns.usda.gov/cr/FNS-non-discrimination-statement. We also have the non-discrimination statement available in Spanish on our website, as well as Vietnamese and Arabic. There's a couple of requirements when printing the non-discrimination statement. The first printing requirement is that the wording for either statement, either the long statement or the short statement, cannot be changed. The state agency has encountered situations where SFAs have tried to change the word sex to gender in the non-discrimination statement, and USDA is emphatic that no words can be altered, changed, added, or removed from the statement. The second printing requirement is that the print size cannot be smaller than the text of the material. Also note that in auditory presentations, such as public service announcements, the shortened version may also be used, but the long version is required on any vital documents, even if it's only 1 page long. The non-discrimination statement is required on any materials that mention the programs to the public. These materials may include advertisements, publications, letters, enrollment forms, broadcasts, school websites, etc. Items that do not require the non-discrimination statement to be printed are incentive items, such as cups, buttons, magnets, or pens, due to the impractical size. Okay, so let's talk about customer service. Customer service is defined as effectively communicating with customers, responding to the customer's needs, valuing their worth, and instilling excellence through courtesy, confidence, and enthusiasm. Treating customers with respect and dignity through excellent customer service saves you time, and it minimizes the opportunities for complaints and angry customers. All students must be allowed equal opportunities to participate in child nutrition programs, regardless of race, color, national origin, sex, age, or disability. All participants of the child nutrition programs must be treated equitably. So in order to reduce the risk of a civil rights discrimination complaint, ask yourself the following questions each time a participant comes to your program for services. Number one, am I treating this person in the same manner that I treat others? Number two, have I given this person the opportunity to ask questions? And number three, have I provided the person with the information he or she needs to make necessary decisions? During meal service, students within the same grade grouping must be offered the same menu selection regardless of their eligibility, sex, national origin, race, color, age, or disability. All varieties and selections must be made available to all students within that same age grade grouping. In the examples provided, it would be discrimination to provide a high school football player a bigger scoop of food or to save certain food items for specific groups of students. USDA policy prohibits the denial of meals as a disciplinary action against a student who is enrolled in a school that participates in child nutrition programs. And it also prohibits requiring a child to work for or to earn their meal. And this is also applicable, just to mention, at RCCIs. Identifying information must not be used for any purpose other than to determine and verify eligibility for free or reduced meals. Overt identification should be considered in different situations beyond just the application process. This includes at the point of service, where other students may see eligibility statuses on the cashier computer screen, or for example, when special functions take place that require alternate meal service types, such as field trips and class parties. In these instances, no overt identification of meal status should occur. In no way is an SFA to impede with a customer's right to file a civil rights complaint. However, most conflicts are easily resolved by using appropriate tools. Conflict resolution consists of useful skills to assist with the solution of complaints. These skills include using a win-win approach. So you can change the conflict from an attack and defense to cooperation and avoid the desire to blame. You could use a creative response by turning problems into possibilities and improving the situation. You can demonstrate empathy to help others feel they are understood by being an active listener. You can use appropriate assertiveness, so you can state your case without arousing the defenses of another person, especially by using I statements to communicate your feelings directly. You should remember to always manage emotions, so stick strictly to the facts of the complaint and communicate your feelings directly. And then also have a willingness to resolve. So identify barriers to the resolution and overcome those barriers. And then also you want to just avoid repeating the situation. But if the complainant persists with their complaint, direct them to file their complaint with USDA's Office of Civil Rights. Limited English proficiency, or LEP, are those individuals who don't speak English as their primary language and have limited ability to read, speak, write, or understand English. SFAs must take reasonable steps to assure meaningful access to the information and services they provide to people with LEP. Reasonable steps would include an evaluation of the following factors: the number or proportion of LEP people eligible to be served or likely to be encountered in the program, the frequency with which LEP individuals come in contact with the program, the nature and importance of the program, activity, or service provided by the program to people's lives, and the resources that are available and the cost to provide those services. A shortage of resources or anticipated costs to provide these services to individuals with LEP doesn't eliminate the requirement to do so. SFAs must explore the most cost-effective means of delivering services and information to people with LEP. All child nutrition program information should be provided in the necessary language for all participants and their families. For example, enrollment forms, menus, brochures, and letters should be provided in the necessary languages for all participants and their families. Language interpreters can be helpful when dealing with someone with limited English proficiency. Volunteers may be used, but they should understand the ethics required when using an interpreter. For example, a Spanish teacher could assist a household in completing a meal application, but they would need to be trained on the importance of keeping all of that information confidential. And also, as a note, children should not be used as interpreters. All schools that participate in a USDA child nutrition program must have a system to collect the racial and ethnic data of program participants in accordance with FNS Instruction 113-1. This data is used to determine the state's compliance with federal civil rights laws. USDA regulations state that respect for individual dignity should guide the process and methods for collecting data on race and ethnicity. Therefore, self-identification or self-reporting is the preferred method of obtaining characteristic data. The collection of this information is strictly for statistical reporting requirements and has no effect on the determination of their eligibility to receive program benefits. This data must be maintained in a confidential file for 3 years plus the current year, and this information should be restricted to authorized school personnel and other authorized state and federal personnel when requested. Racial and ethnic data is used to determine how effectively your program is reaching potentially eligible children and where outreach may be needed. So just as another note, USDA did come out this year stating that race and ethnicity should always be self-identified and shouldn't be assigned by an observer. And I think in most SFAs that is the case, but especially we just wanted to make note of that we're still waiting on further guidance from them. Ethnicity is broken down into 2 categories. There's Hispanic or Latino and non-Hispanic or non-Latino. The racial categories include American Indian or Alaskan Native, Asian, Black or African American, Native Hawaiian, or other Pacific Islander, and white. A person may identify as belonging to multiple racial categories, but will only belong to one ethnicity. So for example, a person may identify as Hispanic or Latino, but they can't be both Hispanic or Latino and non-Hispanic and Latino. They're only going to identify as one. However, that same person could identify as both Black or African American and white. Next, let's discuss accommodating persons with disabilities. Reasonable accommodations refer to ensuring that participants with a disability have physical access to programs and services, such as easily accessible entrances and restrooms, etc. A school is required to provide food substitutions or modifications for a student with a dietary disability. A written medical statement completed and signed by a licensed physician, advanced practice nurse with prescriptive authority, or physician assistant is required to be on file when the request falls outside of the meal pattern. Meal pattern modifications within the meal pattern don't require a medical statement. Meal pattern modifications outside of the meal pattern do require a medical statement provided by a licensed medical provider. In the state of Louisiana, a licensed medical provider includes a medical doctor, a physician assistant, or a nurse practitioner. In the state of Louisiana, a registered nurse or a registered dietitian are not considered a licensed medical provider to provide this medical statement for diet. The medical statement must include information about the child's impairment and how it restricts the diet, an explanation of what must be done to accommodate the disability, the foods to be omitted, and the recommended alternatives. If the medical statement does not fully explain the modification needed, the SFA should contact the guardian for additional information. As a reminder, receipt of clarification should not delay the modified diet. Applicants and participants must be advised of their right to file a complaint, of how to file the complaint, and of complaint procedures. The LDOE recently underwent a civil rights management evaluation by USDA, and from that, several changes resulted in the processes that state agency and SFAs will use to adhere to these standards. The first is a new prototype form entitled Civil Rights Complaint Procedures for Child Nutrition Programs. The second is a new USDA discrimination complaint form. SFS memos 21-120 and 20-121 discuss each of these forms in more detail. When filled out, the civil rights complaint procedures will provide the SFA with the procedures for handling any civil rights complaint that may arise. The form must be completed and kept on file by the SFA, but the state agency doesn't need to receive a copy. Any person who believes they've been discriminated against based on protected classes, which again are national origin, race, sex, color, age, or disability, has a right to file a complaint within 180 days of the alleged discriminatory action. So you can see on the screen here that this is the new version of the discrimination complaint form. Please make sure that each of your schools has a copy of this. It and the procedure on the previous slide can both be found on the CNP website under the civil rights section in the SFS. So if you go to the SFS section of the website and then click on the civil rights tab, you should be able to find both of these forms. The USDA discrimination complaint form must be available at all sites participating in the child nutrition programs. When an individual wants to report a discrimination complaint, child nutrition staff should have as little involvement in the process as possible. All staff must be trained on civil rights and on this civil rights complaint form. Complaints may be written, verbal, or they may be just observed. A complaint may also be anonymous. Anonymous complaints should be handled the same way as any other complaint. If the complaint is verbal and the person alleging discrimination is not inclined to put the allegation in writing, the person to whom the complaint was made must write up the complaint on behalf of the complainant. So the first step is to document the complaint and to make an effort to obtain the following information: the name, address, and phone number of the complainant, the specific name and location of the entity delivering the benefit or the service, the nature of the incident, action, or the method of administration that led the complainant to feel discriminated against, the basis on which the complainant feels discrimination exists. So again, that's race, color, national origin, sex, age, or disability. The names, titles, business addresses, and phone numbers of persons who may have knowledge of the discriminatory action. The date or dates during which the alleged discriminatory actions occurred, or if continuing, the duration of such actions. And then from there, all complaints should then be forwarded directly to USDA. Okay, so here's step 2. The second step for civil rights complaints is to contact USDA. All verbal or written complaints must be forwarded to the Civil Rights Division of USDA Food and Nutrition Services within 3 days of receiving the complaint. And I'll note here too that this is regardless of whether or not the complaint is valid or it's perceived as valid. If your SFA receives a complaint, it's going to be forwarded to USDA. The third step in civil rights complaints is to maintain documentation. So all civil rights documentation should be kept at a central location, and they should be maintained there for 3 years plus the current year. So a few civil rights reminders include: number one, USDA regional office is responsible for the review of the state agencies. And then from there, the state agencies are responsible for the review of the school food authority. So just like our state agency recently had a management evaluation done by USDA about civil rights, from there, the state agency also evaluates civil rights compliance at the school food authority level. State agencies must report any significant findings to USDA. SFAs must receive a pre-approval visit to ensure compliance with civil rights before receiving federal funds. So this occurs, before an SFA comes on board with the state agency. And then compliance from there is assessed through the administrative review process. If non-compliance is indicated, a corrective action plan must be implemented to achieve voluntary compliance within 60 days. The corrective action plan should describe the agency's actions to be taken to resolve the non-compliance. If corrective action is not achieved within that 60 days, suspension of assistance or termination may result. So here's a checklist for civil rights compliance. Civil rights, there should be a civil rights written policy and complaint log. Both of those should be maintained. All staff and volunteers need to be trained annually. And if you keep an eye on our training schedule, in the next 3 months, we'll be offering another civil rights training that your staff could attend. We also post these to Louisiana Fit Kids, the recordings, and that's also something that you could offer to your staff. All staff should know C&P civil rights policy. All sites should prominently display the "And Justice for All" poster. SFAs must collect and record racial and ethnic data. All records must be kept for 3 years plus the current year. You must maintain civil rights complaint procedures and forms. Excuse me. And place non-discrimination statements on all printed materials mentioning child nutrition programs. As a reminder, district policies regarding civil rights complaints should specify how civil rights compliance is handled for the C&P separate from other programs. This is where the completion and use of the civil rights complaint procedures for C&Ps is documented and utilized. Here's a list of resources related to civil rights. And then that's the end of our presentation for today. If you have any questions regarding a specific situation or scenario, please contact the LDOE Division of Nutrition Support. You can call 225-342-9661. Excuse me, I'm so sorry. Or you can email us at childnutritionprograms@la.gov. I'm going to give a moment for people to submit questions, and I'll come back and answer them in just a moment. So the first question I have is, will the PowerPoint be available to print out? So what we post to Louisiana Fit Kids typically is an Adobe PDF version. We even include the notes section of the slides so you can see exactly what we like to cover in these presentations. And that will be available on the Louisiana Fit Kids website within a couple of days, along with the recording. So you can either print out the slide deck, or watch the recording. And I'm going to give another minute for questions. All right, I'm not seeing any more questions. Thank you so much for attending today. We would love it if you would head over to the Louisiana Fit Kids website and fill out the evaluation of this training. Give us feedback, give us ideas of other trainings you would like to see us do. But we so appreciate your time, and we appreciate the work that you do for your communities. So thank you for being here today, and enjoy the rest of your afternoon.